stems from the fact that our law does not provide for a class of creditors, and it doesn't fully enshrine the absolute priority rule. The absolute priority rule is a concept from the US where if the secured financial creditors are taking a haircut, then clearly there is no value left for unsecured financial creditors, and so they're entitled to nil payment in insolvency. Now we have a version of the absolute priority rule in our bankruptcy code in section 53, but it's tempered by the requirement in the code that the committee of creditors needs to treat all stakeholders fairly and equitably. Now, what is fair and equitable is very difficult for judges to decipher, let alone a committee of creditors. And so we're seeing judges struggle with that. The easier and quicker fix would be to treat operational creditors at par with unsecured bank creditors, which is how it's done the world over. And I think that would help resolve this issue. Well, see, the Supreme Court in Essar Steel said that the appellate tribunal need not have gone into this issue, which some would argue has kept this issue alive. Now, what did the appellate tribunal hold? The appellate tribunal held that where the primary debt is either restructured or discharged, the guarantee also stands discharged. Now, that flies in the face of a long line of Supreme Court cases which have held that the guarantee is a separate contract, and most guarantee contracts will expressly provide that even though there's a restructuring of the underlying debt, the guarantee does not get discharged. So the Supreme Court, by not commenting on this issue, as I said, some would argue, would say that it has left it open. And even this Supreme Court a few months back in State Bank of India versus Ramakrishna had held that the personal guarantee continues. I think it was a good opportunity for the Supreme Court to close ranks on this issue and close it out, especially when you consider that in India today, nearly every issue under our bankruptcy law is left to the Supreme Court to be resolved. Contingent liabilities is a very important issue. Bear in mind that the resolution applicant under our law, the savior, the knight in shining armor, if you will, is required to buy the entire company as a whole. Doesn't get the ability to cherry pick assets or cherry pick liabilities. Now, in that scenario, it would be most unfair for the resolution applicant to be saddled with contingent liabilities that it doesn't have visibility on. And I think the Supreme Court recognized this, which is why the Supreme Court said in the Essar Steel order that contingent liabilities are whitewash. In fact, it used the term that there needs to be a fresh start. But I think the Supreme Court could have gone further, but perhaps didn't have the time to go so. For example, in more advanced jurisdictions, or I should say jurisdictions where insolvency laws have been older, there are more advanced rules on what is a fresh start, what is fresh start accounting. And so I think in the interim, resolution applicants will get excited about the fact that the Supreme Court has allowed for a full whitewash of contingent liabilities. I think that's not really the case, and I think it's important to be fair-minded in how you treat contingent liability. For example, it would be imprudent to find that the Supreme Court upheld the extinguishment of all contingent liabilities. Say, for example, current tax assessment years, current tax liabilities. I think it would be unfair to say that they are all whitewashed. Now, Essar Steel during insolvency did quite well. It turned a lot of profit, and as you would imagine, every class of stakeholders laid claim on that profit, whether it's the operational creditors, the committee of creditors, or even the resolution applicant. So it was a critical issue. Now, the Supreme Court in Essar Steel said that given that the request for resolution plan document itself said that any profits during insolvency will be to the credit of creditors, the issue was resolved as such. But it kind of begs the question, what do you do in those cases where the request for proposal document is silent? And which is the case in a whole host of cases. And so the issue remains open. If you ask me personally, during insolvency, a debtor's business is run for the benefit of creditors. So I think the presumption ought to be that any profits during insolvency stand to the benefit of creditors, unless otherwise agreed in a resolution plan. And we have seen instances where it is otherwise agreed in a resolution plan. For example, some plans that I have worked on have seen resolution applicants ask that the debtor be handed over to it with some semblance of a normalized working capital. Now, normalized working capital for a company in insolvency is difficult because, let's admit it, there is really no trade payables. But if you have such a provision in your resolution plan, you could argue that the profits of enduring insolvency can be used to partly offset the requirement of a normalized working capital.